In filing this application, Hamis Kiggundu, represented by his lawyer Fred Muema, discovered that when the appeal was pending judgment before Supreme Court, DTB Uganda and DTB Kenya had introduced new grounds. Following this, they asked court to be given judgment on admission. Kiggundu was of the view that, since in the new grounds, DTB lawyers admit that their client operated in Uganda without a license as required under Financial Institute Act, then the 120 billion was fraudulently withdrawn from his account. However, when the parties appeared at Supreme Court before Justice Elizabeth Musoke for pre-trial hearing, DTB lawyers led by Edward Karugire asked court not to hear the application, that it was overtaken by events.
My Lord, the application that they seek to schedule today is an application that was filed after the submissions had been made by the respondent. So both the applicant and respondent had made their submissions. That's when this application was filed.
They had been filed.
They had been filed. And my Lord, the respondents had an opportunity to respond to the submissions of the respondents. So they had the right of reply, which they exercised. So in effect, my Lord, this application for judgment and admission is an application for judgment as we await judgment. So it is really superfluous and is only intended to waste the time of this court, as for all intents and purposes we are waiting for the exact same thing they seek to apply for judgment. If there are any admissions that we believe were made in the submissions of the parties, and they have responded to them as such.
Karugire told court that justices retired to write the judgment. With this, there is no way court can hear this application. Pending the judgment, Fred Muema, Kiggundu's lawyer, objected, saying DTB's prayers were invalid on grounds that they had come for an administrative hearing but not the main suit.
Applied for admission. You're saying that when you appeared before the panel, which included Justice Appeal,
Yes.
you did not file.
No, there were submissions. The court directed parties when we appeared, because the respondent was raising certain new grounds. So when we received the submissions is when we realized that they had admitted the appeal.
However, trouble came when Justice Elizabeth Musoke informed Hamis Kiggundu's lawyers that nothing much would be yield from the application, since the judgment in the main appeal is ready come 13th June 2023.
But okay, later on, at the reconstitution, they asked, actually, just like Counsel Karugire said, the court asked whether you had anything to say. You said you did not have anything to say. I'm sure the record states that, and that you are just waiting for the judgment. And in any case, if you have those issues which you think should be considered as admission, were they part of the written submissions? Wait, let me finish. I'm sure they were part of the submissions, and I'm sure you responded to them. Unless you're saying that you did not respond to them in your written submissions. But when you were asked whether you had anything to add, you said you did not have anything. That is on the reconstitution date. You did not have anything to add, and you were just waiting for the judgment. And the panel went ahead and prepared the judgment based on whatever they had.
Why would the court call us for pre-hearing to determine filing and format? I mean, we wouldn't even be listed if the court has taken the position that this matter is already just waiting for judgment. The reason the court put us on the list as number one for pre-hearing is because the court recognizes that for 1 year and a half, it has been sitting with an application of a litigant which has not been fixed. For 1 year and a half. Now we're talking of 5 days to Tuesday. But for 1 year and a half, this court had our application, didn't fix it, and we are entitled to be heard. Whether we have merit or not, we are entitled to appear before the panel. We are now hearing the panel's views, not from the panel, but from a member of the court. And we think we are entitled to be heard by the panel, whether we make sense or not. This is our right. So my view is that having been guided for the proceedings of the 5th May, that don't talk about anything else, is only reconstitution. We came to the court as diligent.
As a result, Hamis Kiggundu stormed outside court, followed by his supporters, who caused chaos at court. Court resumed after some minutes, with Hamis Kiggundu whispering to his lawyer, but Justice Elizabeth Musoke ordered him to stop, and he had this to say back to her.
My lord, I want to go on record. I have 1 client or 3 clients who came. No, I don't know. If the court, the case is a public interest case. Everybody knows about it. So, I don't know. That's not my brief. My brief is to argue law here, which I'm arguing. Yes. No, I don't know. No. I don't take responsibility for anything that happens at court. My client is here.
Maybe your client should also get out.
My lord, my client is here. Maybe he can.
No.
You are asking for him, is he?
Yeah.
No, point of information. I'm also a friend and I know that I have a right to be admitted.
You have a right to be heard, but you are talking through your client.
I'm here.
Please.
So that the hooligans
I
brought them.
brought the hooligans.
Okay, you are. There's hundreds of hooligans here.
My lord, I don't know if Diamond Trust Bank deals with hooligans, but by the time they do a transaction for $10 million,
Because they are talking I heard them talking about Kamkire, what?
I don't know.
I don't know, so.
My lord, for us, we are just lawyers.
Not in good favor, so.
I was
they
not
must be
there
for the other party.
when Diamond Trust did a deal with him. I didn't know anything. The case came later to me, many years later. So you can see the situation of it.
Yeah. But I advise him, that's not the way to handle court matters. Okay? By bringing hooligans to shout in court, that will not influence. Me, I'm not part of the panel. I came here for an administrative matter. Okay? And your matter was, they brought files which were supposed to be dealt with administratively. But then,
My client is here.
maybe your client should also get out.
Justice Elizabeth Musoke, however, insisted that the judgment would be delivered. However, it was sad to be swallowed by Muwema, who insisted to meet the Chief Justice.
Mutekewo obwenkanya tetulwana na government twagala bwenkanya mulekewo banka ezitukiriza amateeka naye tufiiriddwa ekimala Hamis yabbiddwa ffenna bannayuganda sente bwe zinaatwalibwa e Kenya oba e India oba ludda waza bannayuganda mutekewo obwenkanya kooti tubasaba tetwagala kwekalakaasa twagala obwenkanya munnayuganda munnaffe abbibwa banka bw'eba tetaddewo banka ebeerawo etya mu ggwanga nga terina layisinsi netusigala nga tukyakola nayo
ate nga bakwata abatembeeyi ababeera wano nga babagamba nti abatembeeyi tebalina layisinsi musiba bannayuganda muzeeyi Kalugire mutuyambe si buli awasa nti omwana wa pulezidenti timujja kukola ebyo ebyekisiru mukwata bannayuganda abatembeeyi obutaba na layisinsi ate kati DTB terina layisinsi ate ogiwolereza kiri owakiwanuka n'okola ebyo Jolly Just kiwanuka jjajjawo bakutya kikyalwanirira e Uganda.
Hamu muna Uganda nze nali kukuba osule kukuba emyaka 15 Hamu yakwata sente ze nanzijayo nampa n'omulimu nkola nze nkola era nfuna emirame nga Hamu mvubuka munanga nkuteko saawe lwaki badde loli ne bamuwa nedda twagala justice mirembe twagala bwenkanya bwokka
banga Hamu bw'aba talina bwenkanya nange muna Uganda sijja kuba na bwenkanya mu nsi yaffe tunenyumirizaamu tutya nga bannaffe banyigirizibwa abaana baffe
muna Uganda ayinza kukola kikolwa bwekiti ng'akikola mu nsi ya Bulaaya lwaki ffe abaffe banyigirizibwa lwaki ayimuka gwe baagala bakubadde ku ttaka tekisoboka nga abasuubuzi bali mu makomera ekitongole ekiramuzi ne paliyamenti y'eggwanga Uganda bayise etteeka bagambe nti munnayuganda wa ddembe okutandika okukola bizinensi awatali layisinsi ng'omuntu wa ddembe naye abaana bali luzira bali likitalya lwa bulayisinsi
ensonga si ya Hamu
y'abannayuganda
ensonga si ya Hamu ensonga ya ffenna bannayuganda abba sente zino wa DTB si munnayuganda bw'azitwala aba atwalidde bamuggwanga lye ate abali wano tebalina bwenkanya tugamba judiciary muteekewo obwenkanya abasuubuzi bamuggala bugazi lwa layisinsi naye eno DTB yawa obujulizi mu kooti ng'eraga nti ebadde ekola nga terina layisinsi naye ng'abaana bali mu kkomera abatembeeyi bali mu kkomera wababuuza layisinsi tewali bwenkanya twagala abakolera wano ba investor nga bakolera mu mateeka nga bwe tugakoleramu naye bwe kibassa ekyo abasuubuzi mbasaba nga ssentebe wammwe tetugenda kuddamu sasula layisinsi mpaka nga tufunye obwenkanya bino tebigenda kuggwa bwe biti
teriiyo muntu buli hooka yenna buli mutembeeyi yenna singa Kalugire okuwasa omwana wa pulezidenti ekikufuula wa kabi nnyonyonyo osegeera kiryowo kiwanuka jjajjaawo Jolly Just yalwanirira eggwanga lino musiba mukwata abatembeeyi wano nga tebalina layisinsi naye abayindi bazze muno bakoze bizinesi balina layisinsi ate mutwasamira Kalugire oba mututta mugenda kututta musaaga guno omusango Hamu musaaga musiba abaana wano nga tebalina layisinsi
kyannaku nnyo bw'aba Hamis Kiggundu n'emirimu gy'awadde bannayuganda asobola okufutyankibwa ate omuntu omunaku asookerwako
era bannayuganda tetugenda kukkiriza kuba twadda kooti gyeraga kooti olwedde eri biased kooti eri mu feva y'abayindi judgment lwaki bagirwisaawo bagamba kino bannayuganda twetaaga obwenkanya.
After court, Hamis Kiggundu's supporters were seen outside court premises carrying prayer cards, protesting the proceedings of court. Hamis Kiggundu addressed the media. However, he was not happy with the way court has handled this matter.
They transferred and punished Adon, Justice Adon, from head of commercial division
to a resident judge in Soroti. So, not even judges have been spared from this kind of impunity and arrogance. So, if judges can be victims to such an impunity, what about ordinary Ugandans? DTB made an appeal to the Court of Appeal. The judges at Court of Appeal ignored the issue of illegality and they never addressed it substantially. However, they tried to protect these foreigners, exploitative foreign banks, by ordering for the case to be taken back to High Court for retrial. However, equally being a land friend, we made an appeal to the Supreme Court through my lawyers, Mwema and Company Advocates. At the Supreme Court, Karujire, out of normal procedure, requested to make additional submissions in regard to national interest. He said, if the case is decided in the affirmative in the interest of harm, it would have a far-reaching interest on the foreign exploitative banks. And DTB had admitted on court record. So, this is the problem we have now. The courts cannot afford, because the court's hands have been tied, they cannot afford to pronounce themselves on the illegality committed by a foreigner, which is very unfair and disheartening, because we've seen our fellow brothers, Ugandans, ordinary Ugandans, being taken to Rizira for trading by the same courts on streets without having a license. They force us to pay trading licenses, and even we are prosecuted for the same. My question is, are the laws in Uganda operating different when it comes to foreigners and Ugandans? Anyway, I think this is a case that all Ugandans should address their mind to and find over-accommodating, because I'm sure the NRM regime is a very good government, and it is because of the peace that was brought by our loved President, General Museveni, that people like Hamu have been able to manage to work on this regime and be successful. So I'm sure if it goes to the President's ears, this matter shall be addressed substantially, for no one is above the law. And Karujire and Chiwachuanoka should stop intimidating Ugandans and all judges. Uganda has no room for impunity and this kind of arrogance. I may be here today, I may not be here today. But if anything happens to me, I hereby declare, just to know it is Chiwachuanoka and Karujire that have taken my life out of this life. No, I can't proceed on what happened to court because it was clear and it is on court record. As you've received it, is that as it is. It is so unfortunate that Justice Winnie-Dolo actually is incompetent, if I can say. And you can hold me accountable for that. He is completely, purely incompetent. He has failed to handle judicial matters, especially in the interest of Ugandans. Now look, he has sent a judge to do his dirty work, which is very unfair.
About the one they are claiming, what can you say? What's your take on this? What's your take on that? Excuse me. What is your take on that? Excuse me. The claim that. What is your take on that? I know manyansola okubaako kyonkola kyonna naye ekyo kyenjagala okulaba mukulu Karujire nze bansiba nga sirina layisinsi ekyo kyokka kyekinzita nze mbabuulidde ekyo kyokka. The main suit between Hamis Kiggundu and DTB Bank is presided over by Chief Justice Alfonso Winnie-Dolo, Justice Faith Mwonda, passing night to Haise, and Justice Mike Chibita, Deborah Namamonde, Susan Nabugudde.
No problem. Ate takimanyi nsobi gyalimu nze mwewuunye oyo mukulu Karujire nze nkubuulidde